Hi, everyone. Welcome to Startups in the Law, presented by JonesKertz, PLLC. Today we have Kyle Kertz here to go through everything you need to know about startups and the law. So with that, I'll bring up Kyle.
Good morning, everyone. Welcome to Startups in the Law. This is the 10th episode of Startups in the Law. We've been doing this since April of 2020, believe it or not. And we found that this has been a fairly educational webinar for people that not only are interested in starting their first business or starting their first technology startup, but also for people that have been who have started a business before, or have a couple businesses out there and are just looking to fill in some of the blanks. To give you an idea, over the last few months, we've sort of built a library up of things to know and what to look out for when it comes to starting a business, whether that be a technology business or whether that be really any kind of small business you might be starting. Today, though, I'll tell you, we are going to be focusing more on some tech startup heavy concepts, some stuff that will affect technology businesses. I did review a little bit of the where our attendees are from and which companies they work for. It looks like we do have a fair mix of people who are interested for the first time, people who have started a business before, and people who actively have a business going on right now and are looking, I guess, to grow that and I guess develop that legal foundation a little bit further. So without further ado, we'll keep moving forward. To give you an idea, our law firm is a smaller law firm, though we are rapidly growing. As a matter of fact, this week alone, I'm actually adding 2 additional team members. Right now, though, as far as attorneys goes, it's just me and Matt Jones. I am the managing attorney and partner here in Texas. I handle all of our Texas clients and Texas matters. Matt Jones is our Oklahoma City and sort of the Midwestern region of the United States, as well as any other potential needs for clients that might be coming from anywhere else but Texas at the moment. So the Matt Jones is unfortunately not here today. I will drag him into this webinar at some point, though. He's a fairly busy guy. He's kind of known as the go-to guy in the state of Oklahoma when it comes to tech startups at the moment and venture capital deals. We are based in Dallas, Texas, and we started the office about a year ago, but it's been growing super rapidly. We've experienced massive growth in that first year. To give you an idea, we took on nearly 100 clients in the first year just in our Texas, just from Texas alone, which is pretty astounding considering the economic environment and everything that was going on in the middle of 2020. To give you an idea, though, as far as my contact information goes, if you ever have any questions, if you're ever looking to follow up on something, or if we didn't cover something that you were interested in that you would like us to address, or if you do have a question for me specifically, feel free to email me, kyle@joneskertz.com, or you can give me a phone call, 214-736-4462. That goes straight to my cell phone. It's our office number. To give you an idea, the reason why Matt Jones's email is a little bit different, I'm technically a partner of Verge Law Group, which is the name we go by in the state of Oklahoma and literally everywhere else besides Texas. Due to some weird naming convention rule for law firms in the state of Texas, we're not allowed to use our Verge Law name because it's more of a corporate or what we call a trade name for law firms. And so I just want to describe a little bit of why that is. It's a bit of a quirky issue. Hopefully the state of Texas comes around and allows us to use our Verge Law name at some point in the future here in the state. But anyways, without further ado, we'll get into the real mission for why we do this. The truth is, when it comes to starting a business, so long as you are better educated, so long as you are more knowledgeable about the different factors to consider, especially as you progress through the life cycle of starting a business, having that better foundation underneath you is going to lead to a more successful business, a more successful startup. We're not talking about hey, we don't want you failing at all. Like, we hear a lot of times when people talk about startups, you need to fail faster, right? Fail as quickly as possible. What people mean by that is sort of just make those early mistakes, figure out what works, figure out what doesn't. But we don't want you truly failing. We don't want your business going under completely. We want to mitigate that by providing you with information and providing you with the knowledge necessary to know when you're sort of out of your element and need a professional like an accountant or a lawyer or somebody else that you might need to bring into as part of your team that you're building around you and your business as you grow. And so with that in mind, this is not a sales pitch. We're not doing this like other law firms. And I have watched other law firms' webinars, and I'll tell you, you can really tell when they're selling it because they'll put all of their practice areas down there. We're not going to do that. This is more informational only. Please do feel free to ask questions. There's a chat here. Please feel free to make comments. Alex is going to sort of moderate these and bring them up to me in case I'm missing something. I will try to pause as we go through these and make sure I'm actually giving y'all an opportunity to pose a question that I can answer. And I will try to go as in-depth as I possibly can when we do that. Okay. So here's a list of topics we're going to cover. I actually got the first two sort of switched up. So we're actually going to address maintenance items for your business, 2020 taxes, public information reports, stuff for Texas, stuff for Delaware. And then we're going to do legal news updates, recent news, things like that we care about. And then we actually had two attendees email me yesterday asking for me to cover specific topics. And both of those topics were things that I don't think we've actually covered that in depth. And I'm actually going to discuss crowdfunding versus traditional capital raises and which makes more sense and why. And I'm actually, normally I would stay very, very general when it comes to something like that. I actually do have some greater knowledge as to which does make more sense. And I'm actually going to give you an opinion on that here in a little bit. And then the last thing we're going to cap off with, probably the bulk of what we're talking about today, is going to be executive employment agreements. We had this question come up. What are the terms? What makes sense? What can the market support for that sort of thing? I'm going to touch on all of that. Okay. So if you do have a question in between, if you have something that might be indirectly related, do feel free to ask it. If I do think some things are a little too specific, meaning they might really be touching on legal advice with respect to your particular business or situation, I'm pretty good at sensing that. And so I'll try to stay a little more general. And then what I'll do is I'll sort of funnel you to my email or funnel you to the chat in some other way, and we can talk privately about that if it affects your business. Just a legal disclaimer, I used to say this. Sometimes I would sort of skip over it just because I would forget about it and just be so excited to move on to the content. But just so you're aware, it's not legal advice for your business. That's not what we're doing today. Please don't act on this info without seeking counsel or seeking the advice of other professionals for the topics that we may be discussing today. And I always say this when I talk to some of our most frequent clients. There are no absolutes when it comes to practicing law. We frame everything based on the facts available and conduct research to reach legal conclusions. We never do anything in a snap judgment. I always double check, even if I do think I know it off the top of my head. And I mean, last but not least, please just remember, if you are not a lawyer, you are not a lawyer. I have seen a broad spectrum of non-lawyers draft agreements, try to do their own lawyering. I would highly recommend against it because you're likely to do a lot more damage to your business or to yourself than you really think or could really even comprehend. So without further ado, we're going to get right into this. So the end of the year, as far as fiscal year, just came up. So for businesses that operated and made money in 2020, if you are a registered Texas LLC, or if you're a Delaware corporation or Delaware LLC or a Texas corporation, and you're registered to do business in the state of Texas, you are going to have to file public information reports, no tax due reports. In some cases, some of the people attending might actually have to file and pay taxes to the state of Texas. And some people are sitting there thinking, wait, what about that? I thought Texas didn't have a state income tax as far as business income goes. That's actually not true. It's just that the threshold is so high that most businesses and most individuals are not likely to have to pay it. And just so you're aware, for 2020 and 2021 taxable years, the threshold for whether or not you have to pay tax is $1.18 million. If you earn more than $1.18 million through your business, then you will have to pay what I would call nominal income tax. You're really only going to pay somewhere between, I believe it's it's so low. It's like 0.375 points, like 3.75% on of the income in tax. It's ridiculously low. But it depends on what kind of business you're actually running, whether or not you'll have to pay that tax, or what level that tax will actually be at. Certain businesses, such as insurance companies, have to pay a tax anyway, regardless. Depends on which industry you're in, depends on how you're regulated under the state law. So you have until May 15th to get your filings in, though. Just keep that in mind. It's not like it's really, really looming over you right now, but it does sneak up on you. We'll wake up tomorrow, and tomorrow will be May 14th, and you'll be like, that guy mentioned it 4 months ago when I should have done it. If you get it in earlier, especially if you don't have to pay any tax, it's just a free filing that you have to do online. You just pull your web file number, you file it, you tell them basic information about the company and who runs it and how much it made in the 2020 fiscal year, and then boom, it's done. And you don't, but just remember, by the way, if you miss this filing deadline, not the end of the world. You just have to pay a $50 penalty. You'll file anyway. I mean, you'll go back active. Just remember though, if you don't file it, you could technically lose your active status. You could have your status as an entity involuntarily terminated for failure to pay franchise taxes, or at least file the no tax due report, which would be silly, especially if you're continuing to operate. Does anybody have any questions about that? I'm about to talk about the Delaware version of that right now. Okay. So this is really brief. Delaware filing deadlines for LLCs is June 1st. For corporations, it's March 1st. You're going to go through Delaware's websites to do that. There are minimum franchise tax fees to pay for corporations, things like that. I believe LLCs also have that as well. I'm not as well versed in that, obviously, because I practice Texas law and the bulk of what we do are Texas entities, though we do a lot of Delaware corporations. We usually say, though, talk to your accountant, have them help you file it. They're used to doing that sort of thing. I'm sure they do Delaware corporation franchise tax filings all the effing time. Aside from that, though, just make sure you're doing it, because you don't want to get in arrears on paying any fees. And just so you're aware, if you do not pay the fees, you do not do these filings, the more that these fees rack up, the more they actually rack up against you personally. The entity itself does not protect the owners from paying franchise tax fees. You must do it yourself. There's no walking away from that. So if anybody has any other questions about that, or if you need links to potentially help you get to the controller's the controller's website to go fill out your no tax due report or your public information report, please let me know in an email. I can drop you the link really quickly. We're going to go through recent news and legal updates. I'm actually kind of excited to talk about some of this stuff because it's come up in our business, and it's some of these are pretty hot topics at the moment. Record numbers of people moving to Austin. So you've heard Tesla is moving and building a factory in the Austin area. It's not quite in the heart of Austin, but it's in the Austin area. It's just outside of town from what I can tell. Oracle is moving. Apparently HP is moving. Apparently other businesses are moving. And along with them, a lot of San Francisco startups are actually moving operations to Austin. part of the impetus for that, if you haven't been reading the news, or at least even just, I guess, glancing at it, the people are just frustrated with San Francisco politics. They're also frustrated with paying high taxes, though I don't think it's necessarily the taxes that were the impetus for this. I think it truly is just it's just the way people have grown to dislike the homelessness crisis in San Francisco, just the general social norm. And I guess San Francisco has just become uninhabitable for some people. And so they're either looking to move to Austin or, ironically enough, to Miami, Florida. I've been to Miami. It seems like a nice place. It's probably not the place I would want to live. I think Austin is a much cooler place to live, in my opinion, though. I can definitely see why people would want to live in Miami, because obviously there's beaches, right? It's honestly great for the startup community, though, that so many people are moving to Austin. As a matter of fact, the way a lot of people, I think, should frame this is, with all these major tech businesses moving into the area, the people who end up quitting jobs at those technology companies are going to be starting local technology startups if they go into business for themselves, or they're going to be joining other local technology startups. I think the pool of talent is going to be exceptional. And so if you're located regionally in the Austin area, it's probably a great time to begin networking with people you might add to your team if you have an existing business that's there. Or if you don't have an existing business that's there and you're looking to move, it's probably a great place to establish some roots for your business, because the truth is a lot of people are not actually from Austin to begin with. I helped start an LLC for somebody the other day that moved from San Francisco to New Jersey to Austin, and they were selling their property in San Francisco, and they loved Austin. So the only downside I think a lot of people are seeing is it's getting a little bit crowded. Austin is actually a big place, but it's kind of a small place. It's actually smaller than the DFW Metroplex. DFW is a bigger place in general. I think Dallas in general as a city is bigger than Austin. And so I think the real estate market is definitely going to get a bit heated. And then as far as, but as far as like restaurants, as far as the social life, as far as going out, once the pandemic is over and we're all able to actually go outside and breathe without a mask on, I think it'll be a great place to live, and it'll be very vibrant for the startup community, even more so than it is right now. I do think as far as predicting certain things about what's going to happen to the legal side of things, to the deal side of things, I think the people who are coming from San Francisco are definitely going to be bringing this sort of feeling of easier flow of capital, easier flow of investment money between investors and startups in the long term. But I don't think it's going to go quite to San Francisco levels. And what I mean by that is Texas, by and large, is very much whenever we're looking at investing in companies or we're looking at doing investments in VC deals, a lot of investors, they often want to see post-revenue. If you don't have a ton of revenue, they definitely want to see that you've identified the customer, that the customer has actually adopted the product, or that you actually have those increasing levels in adoption. We could talk about the other metrics all we want until we're blue in the face, MRR, ARR, whatever you want. But the truth is, post-revenue, post-customer is kind of what differentiates Texas from San Francisco, where in San Francisco, you might be able to actually just make a pitch with a pitch deck. You might have a company set up, but you might not really have much more than a team at the moment before you receive that first investment or seed capital. I think a lot of people in San Francisco are actually relying much more on their prior experience and the fact that they can say, I've exited these companies. This is the stage that I work in, things like that. Potential softening, depending on the sector, it depends on what they're doing. Obviously, if you're doing, mobile app stuff, if you're doing software related stuff, there might be a little bit of softening there. But that remains to be seen, though. That's all speculation. So sectors in tech startups likely to skew a little bit heavier, though, based on companies moving into the region. So most of the people starting brand new companies, I'm betting, are going to be starting companies that solve a problem that they identified when they were working at a place like Tesla or Oracle or HP. So actually they may be doing it with the fact in mind that they are going to turn around and make their former employer a customer of their business. I think that's very likely coming in the next couple of years. But what about Dallas or Houston? So this conversation all revolved around, well, Austin's great, but what about Dallas? And Mark Cuban makes the point that I just made. Dallas is a larger place technically, but he claims it's better, cheaper, more entertaining. I would say better, totally subjective. If I actually live in Dallas, I'm from here, I would argue that Austin is a better place to live for sure. Cheaper, definitely. You could definitely afford to live here a little bit more entertaining. I think what he's getting at there is that there are more sports teams. I would not say it's more entertaining. If you're the type of person who doesn't like sports, but you do like going out to see live bands, then Austin is going to be a much better place for you. If you like restaurants, Dallas or Austin are going to be great. Though if you like Tex-Mex a lot, Austin's definitely better. I'll tell you though, when I read this, by the way, this is from Texas Monthly. I didn't just write all this up and put it together. The truth is, like, when you're looking at Dallas versus Houston versus Austin, it's like apples and oranges. The environments are totally different. I think Austin has a lot more gravity as far as the startup community goes than Dallas does at the moment. As a matter of fact, I was talking to somebody the other day, and they mentioned to me that they thought Dallas had actually lost most of its community as far as startups go because of the pandemic. They feel like it's just not as tight knit anymore. They feel like a lot of people have just a lot of people have lost that sense of community that I think Austin actually does have, and that Austin stuck with. That said, you can't take one person's opinion and paint broad strokes on the entire community. It does still exist in Dallas. I just think it's going to take some time to recover and get back up to the levels that it was at before. And no doubt Capital Factory, the people hosting this, did a lot to contribute to that. And so whenever the pandemic is over, I'll be honest with you, one of the things we can't wait to do is get back into office space, get back into co-working, get back into meeting people again, face to face. But yeah, so another thing that came up in the last couple of weeks, really last few weeks, is the idea of direct listings. So right now, there are two pretty hot topics as far as going public go. Number one, we've been hearing practically every day about SPACs, so special purpose acquisition companies. If you don't know what a SPAC is, you can look it up, but just really briefly, a SPAC is basically a blind investment vehicle that is used by a company to take itself public. The company or some people indirectly or directly related to it will actually form a SPAC. It'll be funded with the assistance of investment bankers. The investors will actually not even know what the target company is, though the target company will usually be predetermined from what we can tell. And then once the SPAC has officially funded, they have a certain period of time to move that money or move a certain portion of the money and invest it in a target company. When they do target that company, the SPAC typically acquires it and takes the name, thus taking the company public. Different than a SPAC, though, is a direct listing IPO. And in the last 4 months since September, direct listings have been up for proposed rule changes. So the first people to ever do a direct listing were some pretty big names: Slack, Palantir, and Asana. I believe Slack was actually the first one. If not, they did the first direct listing really simultaneously with another company. But there have been two sort of conceptions of this. So I was reading about the different conceptions, and actually the New York Stock Exchange's conception of it has been approved. The NASDAQ's has not. But the difference is the NASDAQ believes that you could use a direct listing of stock in a company to create liquidity for its founders, for its early shareholders, for its early investors. So take, for instance, if you were an Austin-based company, you had a private company with 100 million in shares, you had some founders, you had some early employees, you also had investors and just other people you awarded stock to throughout the first couple of years or first few years of the company. Well, if you were valued highly enough, you could, under the NASDAQ conception of this, you could use a direct listing to create liquidity for those people who own that stock. Now, the key difference, though, between NASDAQ and the New York Stock Exchange is the New York Stock Exchange takes it a step further and says, with a direct listing, we could actually use this to raise money and cut out the investment bankers from the traditional IPO process. In other words, the New York Stock Exchange is saying, we don't need investment banks like Goldman Sachs to take you public. We can do it ourselves, and we can lower the underwriting costs to the point where it becomes a really inexpensive proposition to raising capital. And I'm sort of oversimplifying this, but some of the key factors to think about, and I know going public for some people, especially if you're listening to this and you have your own company, you have your own Delaware corporation, if that is on your mind, keep in mind there are some pretty strict rules. It's pretty complex. You're definitely going to be going after maybe a medium or large size law firm to help you with it. But with a direct listing, the capital requirements, the valuation requirements are much higher than a special purpose acquisition company, a SPAC, or really a traditional IPO. So to take a company public through a traditional IPO, you only need $40 million, I believe, in valuation in order to do it, which in my opinion is really low. We can make an argument for a lot of companies that they're worth 40 million. That said, you do have to get an independent appraiser to step in and actually help you with that. So it's not exactly one of those things we can just waltz our way into and draft up a board resolution confirming that we're worth $40 million. It's a little more refined than that. But with direct listing IPOs, because the idea is you're selling directly into the market and you're not going to take you're not going to have IPO participants under the normal lockup terms that a traditional IPO is subject to. The truth is there's potential for greater volatility since you have less shares on the open market, as well as it's just a riskier proposition. But it does solve a certain problem. So for those of you who saw Airbnb go public, you might have seen that their stock price jumped pretty much 100% the first day of trading and has stayed there. It's actually hovering right around $150 a share right now, when it sold, I think, for something between 70 and 80 a share. And the analyst said that they left about $4 billion on the table. Supposedly, the New York Stock Exchange's conception of a direct listing completely eliminates that problem. So you're basically, the people who are purchasing the IPO shares when it goes public will be creating that market. And so there should be no difference between what it initially trades at on IPO versus that's it. What it initially trades at an IPO. There should be none of that disconnect between the IPO participants and the open market itself. There also will be no lockup period, surprisingly enough. So typically there's a 6-month lockup for people who participated in the IPO. You can't sell your shares before then. It apparently eliminates that altogether. So it actually creates more trading volume and thus more liquidity as far as stock traded on the open market. Sorry, I went really in depth on that. If you don't understand that, that's fine. We actually had a client who's interested in doing a direct listing. That's the reason why I brought it up. It's the reason why we know so much about it. So aside from that, if you do have any questions about that, would love to talk to you about it and get your thoughts on it. I do think that what will end up happening is many companies, once they mature enough, they'll actually use a direct listing in conjunction with a venture capital or private equity raise. And they'll do that because, number one, they do want to give their shareholders, their employees who own stock, and the founders an opportunity to actually make some money off of the company that they started or helped start. And it also, the private capital raise will just be a cash infusion that also basically allows for the company to meet its capital and valuation requirements under the law. Aside from that, I do want to talk about this is a question that we don't get all that often, but I have talked with some people about it. What effect does a Biden presidency have on the type of entity tax elections recommended? For now, there's no effect. First of all, I think a lot of people are thinking, what do I do? Well, just there's nothing to do really other than maintain and operate under the same assumptions we were before when we had a different president. So our advice on type of entity to start in your situation, our advice on tax elections does not change and will not change until such point as the tax law is amended. And until such point, we have advice from accountants and all the other professionals and a consensus on what to do as far as starting businesses. And there's a little bit of ebb and flow there, but it's just a wait and see sort of thing. We're not sitting there just in a holding pattern. Well, I say we do not recommend staying in a holding pattern to wait and see. The truth is, if you're starting a company right now or need to start a company right now, there's no reason to wait and see. Just start the one that's appropriate for now. If we need to, we'll make changes later on. It's simple enough as it is. That's what I meant by that. What we do recommend, continue making money, continue growing your business. Just take the advice as it's out there in the market right now. And if the advice changes, ask your accountant, ask your attorney what to do about it. If it does change, your lawyer actually might even just call you and tell you that you probably need to do something about your tax election or do something about your entity type. Okay. So aside from that, do we have any other questions from the beginning? I sort of went through some stuff that I didn't intend to go as deep on the direct listing stuff, but if anybody has any questions about that, feel free to let me know if you have any questions about anything else. Without further ado, we're going to talk about crowdfunding versus traditional capital raises. So we received this question via email yesterday. I have sort of glanced in previous webinars, discussed this concept, but I've stayed away from going really, really in depth on crowdfunding. But we're going to do that today. So for most people, they understand crowdfunding to be we're sourcing capital from a lot of different people using an online portal, basically. So if you look at crowdfunding in the sense of charitable crowdfunding, you might think of GoFundMe. You might think of, I believe there's a business called Robinhood that is different from the Robinhood we all know as the trading platform. You might think of Indiegogo. You might think of Kickstarter. So all of the ones I just described, especially the last two, Kickstarter and Indiegogo, most of the companies that are seeking crowdfunding on there are not actually giving away stock in the company. They're just giving away benefits or what we call perks. And the perks themselves do not fall under the definition of securities under the Securities Laws of the United States. And so what we have been asked about, though, is what about crowdfunding where you are selling securities? So for some of you, you might be familiar with companies such as, I believe it's Seed Invest. .com. You might be familiar with a couple others. I believe Republic.co is another one. You may know some that I'm not even really aware of. There are also some niche ones. So for example, I believe Fundrise is actually a real estate focused crowdfunding investment. And I've actually gone into their structure because I had a potential client who wanted to know how exactly do we do this. And in some cases, those structures are extremely complicated and expensive to create. It's not easy to package crowdfunding in some situations. And I'm going to get into that here in a little bit. But for now, we're going to go through just a word on securities laws, just a little bit of an overview. Then we're going to narrow down and filter down to the actual law. So to give you an idea, if you're framing how securities laws apply to you and your company, securities laws in the United States are the laws of exemptions, meaning we want you to be exempt from having to register the offering in the way that a publicly traded company would have to register its offering with the Securities and Exchange Commission. In other words, are you exempt from registering the capital raise with the SEC before you initiate raising capital? If you're not exempt, it's going to cost you way more money on lawyers. You're going to have to provide way more comprehensive information. It's going to have to be totally GAAP compliant. You're going to have expensive accountants prepare it too. It's not a nightmare per se because it's not terribly difficult to do all of that. It's just a matter of it takes more time, takes more due diligence, and overall takes more money to all of the people who have to do that for you. So most capital raises are what we call Regulation D capital raises. And what that really means is if you fall within Regulation D, we technically do not have to file at the state level in some cases in order for you to be exempt from registering the offering of stock in your company. And that's important because imagine for a second that you didn't fall under Reg D. Well, the problem with that might very well be that you're going to sit there and have to go through each individual state's law on the subject. The truth is, if you have to end up doing that, it can be very expensive. Some states have very expensive filing fees for that. The truth is, though, that analysis, as far as whether you have to file at the state level, has to be done anyway. It sucks to say, while there is state preemption in some cases, we are really looking at, we do want to make sure that we're not running afoul of any of those other laws, right? So I know that's a bit duplicative, but the truth is, usually Reg D is good enough. We don't have to file all the way down to every state that we have a contact with whenever we are raising capital for a company. Because conceivably, if you are raising capital, you really do need to count the state in which the company exists in, as well as the state in which a potential investor exists in. So I've done the research on this. Technically, if you have had contact with some states, with some people in some states, that is enough for you to have to file in that state if you don't have some sort of state preemption from having to file under securities laws in that state. That's getting a little too far into the weeds, but if you have any questions about that, just ask me. Did you make the securities filing is a big question too. The reason it matters more than you know is sometimes people forget to do it. They'll raise $1 or $2 million or even $10 million and they won't file Reg D. To give you an idea, the whole point of filing Reg D is you've basically put the world on notice that you have complied with the standards set forth in the Securities and Exchange Commission, the rules, as well as the acts of the Act of 1933, the Securities Act of 1933. As far as that goes, if you do that and you make the filings on time, or even if you make the filings a little bit late, a lot of times the SEC will forgive that and actually just allow you to file it without any penalty or anything like that. And that's enough to sort of ward off any sort of presumption of fraud in that situation. So the idea is if you do not file securities filings, you are in a way presumed to have committed securities fraud if you go too long without doing it. The legal standard is actually if you don't do it within the time frame prescribed by law, then you are presumed to sort of fall into that red zone. But the reality is a lot of times the filings happen later than the deadline to file, or at least the initial deadline to file. And so I think the SEC is actually a lot more forgiving than most people realize. But like I said, not everyone makes the filings. You should definitely make the filing if you're raising any meaningful amount of money, any money at all, really, and you fall under one of the Reg D exemptions. So moving forward, so the typical Reg D exemption that most people will fall under is going to be 506B. More recently, we're actually seeing a little more 506C. And actually, you may have seen some people who, especially if you are a member of Capital Factory, you may see some of the people that it looks like the people at Capital Factory are investing in. They may actually be publishing online on their social media saying, hey, we're closing our round here in 20 days or 10 days, or we're closing our round at the end of the week. We're still looking for 100,000 or 50,000 in capital. And that's a form of general solicitation. So in that case, they would most likely fall under Rule 506C. They're going to be going after accredited investors only, which means they're going to meet those heightened income or salary requirements or net worth requirements. But typically we see Rule 506B. Both of these allow for unlimited fundraise amounts. So it doesn't matter how much you're raising so long as you fall within these requirements. Regulation CF, though, regulation crowdfunding. The requirements are actually a little bit more stringent. I've researched this very extensively in the past, and I'll tell you, more often than not, when we go down this road, I think a lot of people end up realizing just how onerous some of this stuff is. So let's go through it. You can crowdfund through online intermediary, either a registered broker-dealer or funding portal. These are the requirements, by the way. I got this off of the SEC's website when I did this. The max aggregate funds that you can raise in a 12-month period through crowdfunding. We're talking any amount of crowdfunding on any amount of funding portals, so long as you have done all the stuff that you are required to do under the law. So let's say you had 5 separate crowdfunding campaigns going at once in a 12-month period. Across all of those, you are only allowed to raise $5 million. Now, some of you who might know this rule might be thinking, I thought that was $1,070,000. That's what it used to be up until earlier last year, basically, or late last year, when the rule changed and they raised the aggregate fundraise amount to where the maximum is now $5 million, which actually makes a lot of sense. Under the previous rule, $1 million for a startup company is really not a lot of money. Like it's just not a lot of money at all. And so you're sitting there thinking to yourself, $1 million, why would I even use Reg CF when the average seed round is running 2.2 million, right? And that's actually a true statistic. The average seed round in America, or at least in Texas, I believe, is 2.2 million. So when you look at those numbers, the SEC rightfully said, that doesn't make any sense. Let's just raise it to 5 million. And actually, more people will actually go use crowdfunding as a way to get capital, not necessarily because it's easier, but because they are going to get access to more capital and maybe be able to do a crowdfunding campaign plus a side-by-side traditional venture capital campaign under one of the 506B exempt, an exemption like 506B or 506C, right? So aside from that, though, it limits the amount of investors across all crowdfunding platforms. And then you have to make disclosures to the SEC, investors, and intermediary facilitating the intermediaries that are facilitating the offering. So aside from that, these are literally just the rules that apply. So whereas really we're only worried about Rule 501 and Rule 506 when it comes to Reg D, we're worried about all of this, which is it's a lot to keep track of. And so when I say that it costs more money, we're talking just the research to make sure that you're in compliance is going to cost a lot more than if we did a traditional capital raise under Rule 506B or 506C. I just discussed that they raised the aggregate fundraise amount for crowdfunding to $5 million from around $1 million. If you look at this, we have this $107,000 number right here. That's obviously pegged at they've obviously divided the previous amount that you were allowed to raise in aggregate funds, $1,070,000, and they divided it by 10 for some reason. They just did that. To me, that's completely arbitrary. I have no idea why they did that. I did not read anything, though, last night when I was putting all of this together that there was any change in these individual investment limits or requirements. So as far as we were concerned, all of this stuff about annual income or net worth still applies, and which I think they probably should have changed, but you never know what the SEC is thinking. Some of the stuff they do is, in my opinion, very rational. Some of the stuff they do is absolutely mind-boggling and dumb. But it is what it is. So really quickly, for individuals with either an annual income or net worth that is less than $107,000, the greater of $2,200, and 5% of the lesser of the investor's annual income and net worth. Obviously, the lawyers understand this. The truth is, it's basically saying that there are these really strict thresholds. This means that you are not going to get a lot of money as far as an investment out of these people. It's actually going to be a very small investment, in my opinion, for most people who are investing through crowdfunding. But in some cases, it might be a little bit more for individuals with both an annual income and net worth of at least $107,000, 10% of the lesser of the investor's annual income and their net worth. So the truth is, in my opinion, just this alone is overly complicated for purposes of raising money. In my opinion, yes, we can use technology to implement it, and most funding portals do a good job of that. But to me, it just doesn't make any sense, especially when you consider that we could go back here and say, we don't care what their income really is, so long as we have made the proper disclosures and we raised money according to 506B, meaning we actually did a little bit of due diligence. We figured out whether or not they were accredited, had them certify if they were. If they weren't, we had them fill out an investor questionnaire to figure out whether or not they're sophisticated enough under the law to pass muster as an accredited investor. And it is important that you're classifying those people. So keep in mind, by the way, whenever we're sitting there counting non-accredited investors, do not forget to count yourself. If you are a not accredited investor, if you're not meeting those threshold requirements. Apparently, a lot of people forget to do that. Aside from that, though, you must file an offering statement with the SEC in advance of conducting a private offering under Reg CF. That is a major, major difference. You cannot expect most people, once you tell them that, they're like, no, we don't want to do that, because the whole point of securities laws is to obtain the exemption from registration. That alone is basically registration. And that's why, in a way, I actually call Reg CF the non-exemption exemption. You're basically having to do everything that a normal publicly traded company would have to do if it were registering a public offering. And so you're sitting there scratching your head thinking, why would I do that? Why would I spend all the money? Well, in some cases, it might actually not be that hard, because through Edgar, if you're doing Reg CF, apparently there is a fillable form that you can use. And there are things that they actually make it a little bit easier for you to fill in the information to comply with the regulation. That said, the financial statements you produce have to be GAAP compliant. In some situations, the financial statements you produce do not have to be GAAP compliant. It's important that you never did any previous advertising if you're doing crowdfunding, because if you did, then in some cases you'll have to do what you'll have to abandon the fundraise, which, depending on who you talk to, some people will say we really need to wait 3 to 6 months to make sure that we're not raising any money for that period of time to fall within some sort of safe harbor, or to fall within some sort of, I guess, quasi legal situation where you're okay to begin raising money again under Reg CF. The truth is, though, if you're listening to all of this, it's just adding up that maybe this doesn't make a whole lot of sense, right? So what do traditional VCs think of crowdfunding? This is maybe I should have front loaded with this slide and then gone into the rest of the details, the more boring stuff. But the truth is, venture capital firms, VCs, angels, they understand what crowdfunding is. You're never going to fool them. They're never going to be misled as to the truth of what a crowdfunding as what crowdfunding does. It's a lot of hype, technically. For the most part, you're not proving, in their opinion, that the product or the service that you've created is sound. You're not proving customer adoption. You're not proving any sort of traction that we would otherwise have. Any sort of other traction, but it basically just proves you can raise money, and it proves that you can build hype. And actually, there is a cottage industry of crowdfunding marketing companies that will assist you with compiling all this information, talking to the consultants and the accountants, getting all the paperwork set up, making sure it looks really good, and then putting together your video for your pitch and everything like that, making it super dressed up. They get paid very well to do that sort of thing. And usually it does result in additional conversion of people who watch that video and then make an investment. And so, like I said, a lot of hype. You're not necessarily looking at the product, touching the product in the way that you would if you were a true investor. You're not necessarily using the app technically. I'll be honest with you, I've never really seen a company that I thought was worth investing on one of those crowdfunding platforms, but you never know. And also, one of the things to keep in mind is, if you actually drill down into the structure of those companies, in my opinion, they're very misleading about how much you own. As a matter of fact, and it's actually almost completely deceptive, where they're sitting there saying we're selling 100 million shares, but they're not telling you that they're not telling you that they have a standalone LLC set up for that, or they have a standalone subsidiary corporation off to the side. They're not telling you certain other things that actually factor into it. In my opinion, they're actually creating almost a tranche of shares, setting those off to the side. They're for investment. If the investment goes bust, it's not like they'll ever owe the shareholders anything, in my opinion. And actually, it's very sketchy. So, and in some cases, they can actually exceed the fundraising goals, and they'd be forced to take on the additional capital per the agreement they have with the crowdfunding portal or the website. And so that, to me, that's not what you want. You absolutely want to cap off a fundraise and be able to tell investors that you don't want anymore, unless of course you decide as the CEO, or the board decides, or the stockholders together decide, you know what, actually, let's take on the additional capital. We could use it. We could find a purpose for it. I just don't see a whole lot of benefit there. I think with the $5 million aggregate fundraise amount, though, that new maximum technically changes this a little bit. It changes some of the advice, but I'll tell you, more often than not, most people will look at this and they'll realize that it's just not for them, right? Or they'll realize that our company's too early to even really produce financial statements. We could produce a pro forma, but you're talking about well, what does the company look like right now? And certain crowdfunding portals have strict guidelines as to whether or not they will take you on for crowdfunding purposes. They'll say you have to have revenue of this, you have to have assets of this, you have to meet certain requirements for them, because it's not that they're vouching for you, but it's more along the lines of that they want the investment to actually have a chance of working out, so that it doesn't turn into so that the entire marketplace for those things doesn't turn into Ponzi schemes. So, yeah. Aside from that, which makes more sense and why, like I said, there's less scrutiny under Reg D, less hurdles to jump through under Reg D. The source of capital, in my opinion, is going to be more likely to be from the angels, the strategic investors, the venture capital firms. If you go through a Reg D compliant exemption, the Reg CF, in my opinion, is just, you're just getting way too far away from where you need to be if you're an early stage company. I think and to be honest with you, I think a lot of the companies that actually do go forward with crowdfunding, I think they're probably thinking once they've gotten all the way past all the registration and all the filing requirements and done everything they have to do with the funding portal, they're probably sick of it at that point, because they realize that this just not the it's just a less efficient manner of raising the same amount of capital. So I just talked for a very long time. Does anybody have any questions about regulation crowdfunding? So going forward, let's see, executive employment agreements. So we had a question about executive employment agreements yesterday from somebody that signed up for the webinar. So whoever that is, thank you for attending. The question was more around how exactly do we bring on C-level executives or officers or other executives that might not be C-level to help grow our business? What do the terms of those deals look like? How do we structure them, et cetera? And they even asked, what does salary look like? What does equity compensation look like? What do the other terms of the agreement look like? So we're going to go into that. Previously, I've addressed executive employment agreements generally, but I never did really go into these specifically. I never did go into the gamut of the documents that you could have under an executive employment agreement, or stuff that sort of goes indirectly with an executive employment agreement. So we're going to go over this. So feel free to ask any questions you have about this. I'm sure one or two of you will have a question on it. Generally speaking, if you are still in the negotiation phase of negotiating somebody to come on to your business as a C-level executive, if you're an early stage startup, if you're an early stage startup and you're looking to bring on a level executive, a good place to start is a term sheet. The term sheet will lay out the basic details of what is going to go in. So most importantly, we're going to talk about salary. We're going to talk about benefits. We're going to talk about equity compensation. We're going to talk about how long that person is going to be expected to stay on. We're talking initial term. Will they be renewed automatically? Will they be renewed by notice? What other terms go into it? Will there be, and it gets as detailed as a waiver of jury trial, an arbitration clause, even down to the specific type of arbitration clause. So, but as far as what you're looking to do, it's all very situational. So I would say the further along you are, the larger the company you are, the more likely it is that you're going to need a long form version of an executive employment agreement. That said, that's not always going to be the case. Sometimes it makes more sense to have a short form version. And, we battle with this internally all the time. When I talk to Matt Jones, when I talk to our support staff, which one makes more sense? The deal makes more sense if the person is willing to sign it. So if we sit there and say, we've got a 15-page employment agreement and the person is willing to sign it, And then we turn around and go, okay, but what if we use the long form version? That long form version is 35 pages. Well, to be honest with you, most people don't want to read a 35-page contract, even if it does involve substantial rights that they might have, even if it does involve potentially millions in upside or income for them. They just don't want to read a longer agreement. That said, I think that's a bit foolish approach, because in many cases, more is more in that situation, because we are actually leaving things unsaid when it comes to short form versions of agreements. But we do, just keep in mind, we actually do have a short form, a medium form, and a long form version of all of those agreements. And so we judge which one we'll use based on the situation and based on who we're dealing with. And sometimes we actually do just ask a pointed question to the client: how long does this agreement need to be for us to get a deal done, right? Because we don't want to sit there and draft a 35-page agreement, realize it's not effective, and then have to go draft another one that's half as long. Because it's just, we're not in the interest of wasting that kind of time and wasting the client's money. So aside from that, when it comes to additional agreements, we're looking at agreements granting equity or options. So restricted stock purchase agreement, stock option agreement, stock appreciation rights, stock awards, you name it. I'm probably not mentioning a few of them. The reality is it depends on the situation and what rights you want to give that person. So there's something new here, though. If you look, good reason waiver due to COVID-19. The last slide of this deck is actually going to talk about that. And I'm going to give you an example of what that is. And just briefly, when COVID-19 first came about the middle of summer is when I discovered that people were actually starting to incorporate these in executive employment agreements. They were doing it to protect them in a situation where the business is suffering from hard financial times, or the people at the very top need to take less in pay in order for the rest of the company to really survive and weather the storm. And the good reason waiver due to COVID-19 actually allows for reduction in salary for those individuals. Pretty significant. It's not a total solution, and in some cases the executive employment agreement can actually cover, I think might cover some of that, something like that a little bit better, but something to consider. And then last but not least, whenever you're doing anything like this, a board resolution is going to be necessary. If you're granting stock through a restricted stock purchase agreement or some other stock right, you're probably, if it's not granted through an equity incentive plan that has already been approved, where the shares have been allocated to the company, you're probably going to have to get stockholder approval as well. So just keep that in mind. A board resolution is not a total solution. There's not a total approval of all of that, unless you have done certain things right and made sure you've actually checked those off the list. So key terms, and these really are pretty much all of the terms that go into these agreements. Position, title, responsibilities. It's important whenever you're drafting these to make sure that you're authorizing the person to do certain things. And you're being fairly black and white about, in some cases, how much authority they have to drive the company into debt, whether or not they have the authority to sign for certain things, et cetera. You really, in some cases, we want to make that pretty clear. In some cases, it has to be left up to the discretion of the company, board approval, et cetera. Effective date versus start date, those are not the same thing. The effective date of an agreement is just basically the day that it's signed, or the day that, once executed by both parties, it is recognized to have legal effect. The start date of employment is totally different from the date that an agreement has a legal effect, if that makes sense. Employment term, minimum service term. I'll go into that here in a little bit. Term renewals, base salary, equity comp, bonuses, cash equity bonus for signing, not as common for early stage startups, though sometimes could happen if you negotiate it. Other benefits, we'll talk about that in a minute. Termination rights, that's by far one of the most important things. We will talk about that. moral turpitude provisions, talking about that too. And then the remainder of that, as far as non-competes, non-solicitations, non-disparagement, those are lumped into a category of what we call restrictive covenants. I will talk about that because we do have a good example of where restrictive covenants really matter in employment from even just last week. So without further ado, position and title. You need to choose a title for the individual that your customers, vendors, and business partners will recognize and respect. Don't give them something that isn't in line with the industry, that is super weird. Unless your thing or unless your brand as a business is being eccentric, people are just going to be irritated by having to call people certain names that they would consider odd. So make sure when you're choosing a title that it's appropriate for that person's role and that their title generally describes what that person is going to do at your business. So if the person is going to be a chief marketing officer, they're probably not going to have the same authority that a chief financial officer would. If they do, you might consider having them have both of those titles, if that makes sense. The responsibilities, define what you can, leave up to the discretion of the parties if you cannot define certain things. For startups, this is a little more dynamic. You're wearing a lot of hats. You're definitely assuming certain roles, even though that might not be your day-to-day. And that's just a matter of, that's just the game of startups. So we try not to box ourselves in too much. And that's why I say leave it up to the discretion if you cannot define. If you need it to be more flexible, make sure it's not too narrow, if that makes sense. Who does a person ultimately report to? Tell them they report to the CEO, they report to the president. You don't want to leave that unspoken for. You have to tell them who they report to, because that's the person who's ultimately going to decide whether or not they get fired at some point. Initial employment term. Honestly, it's not even worth it if the person is working for you for less than 2 years, unless it's sort of a test period or they just want an 18-month engagement and you're cool with that. Honestly, 24 months, in my opinion, is almost too little. Really, it's hard to make an impact with any less than 2 years. The sweet spot is really 3 years. 36 months is good. Any more than that, and some people I think might get they just don't want to be boxed into having to be there for 5 years, right? It is what you negotiate to. So like I said before, no absolutes. Whenever you're negotiating these, keep in mind, these people might want to do other things. They might get bored easily. And some people, they're pretty restricted to the stage of startup that they actually go to work for as a C-level executive. They might grow you through Series A, but they don't want to be around for Series B or Series C. And so understand what they want out of that. Understand where they come in and where they fit in, because it's possible that the role might outgrow their ability, at which point maybe we decrease the amount of time they spend with the company or decrease the minimum term and just make sure we have the renewal language in there. And I do say, just include the renewal language in there. It's very easy to just put a term in there that says, this will automatically renew unless we give 90 or 60 days notice prior to the expiration of the term. And that's pretty flexible for both parties. 60 to 90 days notice is fine. The only thing that people might negotiate if you do that, they might want severance, especially if it's a without cause sort of thing. Because with startup companies, with people who are C-level executives for technology companies that are privately owned, can be kind of difficult to find another gig within the next 6 months. And so they might need a little bit of that buffer. Just keep that in mind. It's not unreasonable for them to ask for that if that's what you're getting out of it and it benefits you, right? Aside from that, salary must be negotiated. There's no one answer. I've seen it where the salary is like $20,000 a year. I've seen it where it's median salary or it's $48,000. I've seen it where it's basically just a stipend. These people are getting the bare minimum to live off of because all the upside is in the company that's profitable already. In other situations, I've actually seen those terms where it was $10,000 a month. 120,000 a year is not bad salary. That said, if you're paying somebody 120K, we're definitely deducting a little bit as far as the equity goes, because you don't have all of the income at risk at that point, is what we say. You're way more cushioned by your role than most other people in that situation would be, especially if you're at an early stage company. A $120,000 salary is going to be for somebody that probably has a very good track record, has a history of exiting, or at least of being an absolute rainmaker. And then on top of that, they're basically, they may not be as interested in the equity. They may be a little bit older. They may not think, I don't need the upside as much. Aside from that, though, equity, stock options are a way to go. You can do that. It is common to do that. The stock appreciation rights, not really as common, though. With a stock appreciation right, you're really just giving. They're really interested in the profit based on the fair market value at the time they came in versus the time they end up leaving, or the time that they end up getting that stock appreciation right granted to them. It's not actually ownership in the company's shares of stock that they're getting. They're just getting a right to the difference in that stock, if that makes sense. And it can be an interesting vehicle to use. There are scenarios in which it makes sense. We recently had a company here in Texas that is one of our clients where it actually made more sense for us to issue a stock appreciation right, because we didn't actually have to convey anything to them. And it appeared to us that the share calculation was just getting potentially, it was just going to be too difficult to calculate. And it was better for the company to just retain ownership over the stock itself. That said, if you get a stock appreciation right, sometimes you're not getting the voting rights along with that. If you want voting rights as part of being granted stock rights or stock itself, that has to be negotiated too, just so you're aware. Restricted stock units. Restricted stock versus restricted stock units is slightly different, but I would say more common is restricted stock grants, not the units grants. The reality is restricted stock, sometimes we have people sign a restricted stock purchase agreement. Those are very standard agreements. And as a matter of fact, I prefer them in many situations, especially if we're not necessarily fleshing out the C-level executive employment agreement too much. We're just sort of saying, we're granting you this stock in exchange for service to the company, because it does come with certain provisions. For instance, down at the bottom of ours, we have a clause that says no right to continued service, which basically gives the company the ability to terminate the agreement at any time. And at which point, in some cases, we could actually cut off the vesting period whenever we do terminate the agreement. So then performance-based awards. So if you're hitting milestones, if you're hitting sales goals, if you're hitting other things that make a lot of sense when you're incentivizing employees. For instance, if you have a CFO and you want to incentivize that person to raise money and actually get you to the close of a Series A, we can make that a performance-based goal. We can say, you've got to raise a minimum of $2 million in order to get this amount of equity. That's perfectly reasonable. And we often include that just as a schedule or an exhibit to one or more of these agreements in order for them to get access to the stock, or get access at least to exercise the stock. For example, with respect to stock options, by the way, you have to exercise the option at some point. In some cases, we're making the person purchase the stock at a price, at a predetermined price. And so if That's slightly different than a restricted stock purchase agreement where the person is just getting service in exchange for stock. Other benefits, talk about health, dental, 401k, other, if you have to wear suits to work and you have to wear formal attire literally every day to do your job, sometimes we'll throw in other things like that. Car allowances, for instance, we'll say you get X amount of dollars a month. This is for maintenance and upkeep on your car as well as gas. It's a lot easier to do car allowances than it is to actually pay them by the mile, which is just ripe for abuse and fraud. Because if most of y'all are probably familiar, but the rate if you're paying somebody by the mile to drive a car for work is 57.5 cents a mile. If they're being reimbursed for the expense on their vehicle, which is just, it can really add up. Do we have any questions up to this point? I still have a few more slides to go through, but we're reaching the end. Okay. So aside from that, for cash bonuses, for early stage companies, my recommendation to you is make these discretionary. We're not going to sit here and say everybody gets a cash bonus of this amount based on this percentage every year. You got to have a really cash heavy business to guarantee that sort of thing. Bonuses in that situation should always be discretionary. As a matter of fact, pretty much every large company, larger companies, including publicly traded companies, shy away from contractual bonuses for certain employees or employee groups to ensure that they're not totally underwater on how much additional compensation they're going to have to pay at the end of every quarter, semi-annually or even annually. So later stage, they do actually maybe bake them into the agreement. It is commonly negotiated for executives. If they negotiate it, though, I'll tell you, if I was negotiating it, you're not getting that. We can work on the other terms. I'd rather agree on salary to pay you, because a bonus itself has to come from somewhere else. It's easier for us to just allocate something in advance. But when you're working with percentages and cash bonuses in that regard, if that person really hits their milestones and we did something wrong and the numbers were way off, the company could get absolutely killed on the amount of money they owe. And so it protects everybody all around, and it protects the company all around if we just refrain from agreeing to that as far as just hard numbers. Equity bonuses, those are pretty common. Like I said, performance-based bonuses, that's fairly common, but those are heavily negotiated. It takes time to flesh those out. It takes time to agree to those. The last one we did took a month and a half, 2 months, something like that. And it was just back and forth. We just different iteration of the same document. And it works out that way sometimes. Signing bonuses. If you're drawing somebody away from another company, if you're drawing somebody away from a job that pays them really well, it does make sense to actually give them a signing bonus in some cases. So don't ever think, we will never pay that. The equity should be enough. The compensation, the salary should be enough. The benefits should be enough. Some people, they're looking for a little security for the job they just left. They're looking for a little something additional to ensure that they're covered for the additional expense it took to basically quit that job. The only thing I would say is double-edged sword. If your signing bonus is equity and you're not restricting it in a way, or you don't have a clawback on it, giving somebody equity right at the start of when they sign with you is, in my opinion, it happens, but it's not as frequent. We don't do that as often, I would say. We usually wait a few months before they end up getting granted their equity. We usually don't do it right away unless the client asks for it. Restrictive covenants, non-compete, non-solicitation, non-disparagement. So we got about 10 minutes left. I'm going to go over this really quickly. For C-level executives, if you're contributing a lot of value, if you're gaining trade secrets, if you're gaining way more insight than any other employees in the company go, technically we could restrict you to higher or more, like to greater durations of time with respect to non-competes, non-solicitations of customers and employees, and other restrictive covenants. The only thing I would say is most people are never going to agree to a 5-year non-compete. As a matter of fact, 5 years is basically the upper limit on any state's non-compete law, especially Texas. So you really need to consider when you're doing these, what's reasonable? Am I going to put this person out of work for forever if we do this? No, we don't really want to do that, because the truth is we are worried about this person's happiness. Some people are pretty shrewd, though. They don't care as much. We do want to come off as reasonable. We want to make sure that they feel good about the agreement as well, but that it protects the company. So I err on the side of, when it comes to C-level executives, we start at 3 years. Some people try to negotiate down on it. I'll sometimes give a little bit of ground on that and say, we'll do 2 years, that's fine. But sometimes we just say, no, it's 3 years. We're not changing that, change it back. Aside from that, though, I will tell you the most recent instance in which we had, it was actually very fun to do this. We had a client receive a letter from a large law firm, a large national law firm, on behalf of his former employer, telling him that he had continuing obligations under the agreement, that he had a non-compete, that he had a non-solicitation agreement in the state of Oklahoma. Now, keep in mind, we do practice in Oklahoma City. We have an office there, and Matt Jones is licensed there. So we handle that sort of thing on a regular basis. The truth is, this guy originally came to us for advice, and we advised on it. And we basically told him, you can sign this. It's not going to be enforceable. So we're not going to ask them to change it at all, because we don't want them to make it enforceable. And that's what they did. He signed it. And then he quit 3 months later and decided to go out on his own. They drafted it. In my opinion, it was the agreement itself and the restrictive covenants in it were drafted for a different state, not Oklahoma. Oklahoma's very strict rules. If it doesn't adhere to the language under the statute, under the law itself, you're technically not going to be able to enforce that clause. And it is brutal. And as a matter of fact, I'd actually see the hits on our website from the attorney that received our letter when we told them this is totally unenforceable. And in the event you do try to enforce it, we'll actually go to court in Oklahoma and sue to have the court declare that the agreement is, that the restrictive covenants, the non-compete and the non-solicitation provision are unenforceable. And the truth is that's what we would have to do in that situation. And so drafting non-competes, the lesson learned here is they need to be drafted really for the particular state in which the services are to be performed in. And that brings up an interesting issue. So we work from home a lot now. Technically, I could be in Florida and do my job just the same as if I were in Texas. So in that situation, you could be sitting there saying, well, the performance was in Oklahoma physically, but technically the impact was in Texas. And so if I would say, thinking of it that way, if the overall impact of that person's role is actually more in another state, is more in the headquarters of the state of the state in which a company is located, then maybe that controls. In the previous situation, though, this client that we were helping out, the industry was medical device sales. And the truth is the impact overall was actually in Oklahoma, despite the fact that the entity was another state's entity, despite the fact that the governing law of the contract was another state's governing law. The law told us that technically the Oklahoma law governed that contract, not Missouri law. It doesn't matter what the contract said. In that case, because Oklahoma law governed, the agreement was not enforceable as far as the non-compete and non-solicitation go, and the courts would serve to strike it from the agreement itself. The rest of the agreement would survive technically, so long as the other provisions are enforceable, but those provisions alone would not be. So you really do need to draft these with the intent in mind that it's a matter of where the impact really is, especially in that work from home context. So if you have somebody from California serving a Texas company, then we may have a wishy-washy issue. You can technically attempt to claim that the non-compete should be in Texas. Technically, California does not really enforce non-compete agreements unless they're in certain situations, such as an executive that's also a shareholder. But it's an interesting issue. I would say, though, the default really goes to make sure that you have read the law, or that your lawyer has read the law on whether or not the non-compete is enforceable. Because I guarantee you it's pretty embarrassing for that attorney that was representing that large medical device sales company to have to tell their client, hey, that agreement that we helped draft for you, it's not really enforceable because the performance of it was exclusively within the state of Oklahoma. Now, keep in mind, though, the state of Texas, non-competes in general are going to be enforceable. In the states, if the non-compete is written so broadly that certain parts of it would be unreasonable, the courts actually have, I believe it's statutory permission, authority, what have you, to go ahead and change the terms of it so that they are reasonable, and then impose those terms against the party. Aside from that, though, just make sure when you're drafting a non-compete that the scope of that non-compete is within the industry and with similar businesses, with the industry and with similar businesses in mind that person might go compete with. Likewise with non-solicitation, you're worried about them taking your current customers. You're worried about them taking your current employees, your current independent contractors. If it's a past customer, a customer that person maybe knows that person left because they didn't like you, they're never going to work with you again, you could try to enforce it against them if they go after past customers. But the reality is a lot of courts will not look at that too favorably. They'll say, those people didn't want to work with you anyway. You can't do that. Okay. So just keep in mind, it generally needs to be narrowed to the people that the employee at the time knew of. They basically have to be on notice of those people, of the customer's existence, of the employee's existence, of the independent contractor's existence. Yeah. So termination rights procedure, I'll go through this really quickly. With cause versus without cause. As a general default, you want without cause language, without cause termination language. The reason it has to do with creating that at-will employment relationship. You want to be able to hire and fire people without any sort of other restriction. The only problem with that is sometimes when it comes to executives, you're not going to be able to do that. The reason you're bringing them on is so that those people have discretion and that those people have security in their job to be able to make hard decisions. So in some cases, they do need a for-cause provision. They will push for with cause or for-cause termination. But in general, as far as employment lawyers go, I think a lot of people actually look at that as a potential negative. Because in a sense, if you do have to terminate the employment relationship with those people, you're creating a situation in which you could you could likely be sued as a result of it. It happens very often whenever you're claiming a reason for why that person should be fired. The argument goes that they'll say, that's not the case. I told you it wasn't. Here's my emails. Here's my text messages. That's obviously not a great situation to be in. You don't want to be hashing all that out in court. You don't want your dirty laundry being aired out about what's going on as far as the inner workings of the company at the highest levels. And so in that situation, if you are going to agree to with cause, make sure you get binding confidential arbitration in the agreement, because you need it. You probably need it regardless, but you especially need it if you're agreeing to a for cause termination, because it could blow up in your face. Aside from that, the for cause termination is, in some ways, we call it moral turpitude. The moral turpitude is more of a line. It's just a phrase that often gets used, and it's really just one line or one phrase within that for cause definition. Examples of it really include this illegal conduct, gross negligence, fraud, embezzlement, misappropriation, guilty plea to felony, or accused crime involving moral turpitude. In layman's terms, if it's something that Harvey Weinstein did or Bernie Madoff did, don't do that, because it's grounds for termination regardless. And by the way, if we do discover that you've embezzled funds, your employer does not need to sit there and tell you, we're firing you because you embezzled funds. They can just fire you without cause and then claim that later and sue you for it later. So, by the way, your role as an executive does not shield you in any way from a claim of fraud or a claim of or illegal conduct or embezzlement like that. You are not protected from crimes like that or as far as your personal being goes. So, and last but not least, here's a good reason waiver due to COVID-19. If you're interested in reading this, it's really the second paragraph, in my opinion, that matters here. Where it says the company agrees to reinstate your current base salary. And then it goes on to say in the second clause, effective. And here's where I would actually cut some of this. I wouldn't leave that date in there. I would just say as soon as reasonably practicable, taking into consideration the company's financial condition and other relevant factors. It is actually the case that if you are adjusting somebody's pay, that you can reduce it if they've agreed to something like this. That said, it's not a lease. It's not permission from the government or from the courts to sit there and say, I can pay that person nothing because I have this. Reasonable compensation is reasonable compensation. You can't erase what they were supposed to earn. You can only reduce it. And it needs to be reduced to a reasonable level. And a court, by the way, will, in many cases, see right through what you're doing. And they'll say, and just for the sake of being reasonable and making sure that there's an equitable resolution to a dispute, they'll go ahead and say, if you lowered it to zero or lowered it to virtually zero, that was totally unreasonable and not within the scope of the agreement. So aside from that, let me see comments. Let's see. Could you touch on LLC versus C Corp for a startup and incorporating in a state versus Delaware? Yeah, sure. So LLCs versus C Corps. As far as starting a business goes, I think the inquiry really lies in whether or not you plan to raise capital at some point. So if you do plan to raise capital, if you do plan to sell shares of stock in your company in exchange for money so that you can grow in a way that's not organic, I would probably recommend that you be a C Corp. Whether you're a Texas corporation or whether you're a Delaware corporation depends on what you want, but the general consensus is a Delaware corporation is best fit for selling a stake in your company to venture capital investor or angel investors or to other potential shareholders. You can do the same thing with an LLC. It's just a little bit different. You're not necessarily issuing additional stock to that person. You're really just going to be dividing up the bank of membership interest amongst the individuals that are the individual members. In other words, the owners. When in the life of a startup is the right time to incorporate for a startup? Interesting question. The answer to that is actually whenever you are creating. In my opinion, it's dependent upon whenever you are creating debts or obligations on behalf of the company, or when you are doing something that could be considered to create a debt or obligation. In other words, you want the company to shield you from being personally liable for that sort of thing, for being personally liable for any statements made, for any agreements entered into, things like that. Keep in mind, an LLC and a corporation represent a zone of protection around you. You're really getting the benefit of that when you're doing deals, when you're talking to people about potential investments, things like that. If you don't have an entity set up and you're already engaging in contracts, but you're doing so under your future entity's name, you're still personally liable for all of that. Just so you're aware, it's just that's a pretty hard and fast rule. As a matter of fact, if you want a local example of that, there's a business called Condom Sense here in Dallas that apparently when they first started out, they didn't have an LLC set up yet, but they entered into a contract under the LLC's name. They ended up, the guy who started that company ended up being personally liable for his commercial lease obligations because he did not yet form his company before he entered into that sort of agreement. So timing is everything there. If you're about to enter into an agreement like that, you should have a corporation or an LLC set up. Do you have any articles you recommend with more detail on some of those potential direct listing changes? I can provide you actually with the proposed rule change if you like. I can go ahead and email that to you. I can email it to everyone if they like. Just keep in mind that this stuff is still maturing in the market. We're still sort of seeing how it plays out. So the direct listing stuff to me is interesting as a startup attorney because it's almost like IPO light. We don't have the capacity as a smaller law firm to really do full-fledged IPOs, which are underwritten by New York or Wall Street banks. But the truth is, if you do a direct listing and it is simple enough, then conceivably someone like us could, so long as we've got our ducks in a row, we're doing the due diligence. I think actually you may see a cottage industry of smaller law firms doing those sorts of things, despite the fact that they don't have a lot of support staff on hand. Because if the New York Stock Exchange is correct and everything I've read up to this point is correct, then it should be a less cumbersome and a more approachable process for most lawyers who do startup or tech law. So when preparing a fully diluted cap table, would that include stock appreciation rights, or because they're not guaranteed, can they be left off? That's an interesting question. As far as that's probably one of those things that I would actually have to look back into the agreements to see if they're counting it as fully diluted. Don't call me on this, but from what I understand, just off the top of my head without having to look at it, I'll look at it right after this. It's not necessarily that we're setting that stock totally aside for those people on a fully diluted basis. It's that it's just out there. It's a stock appreciation right on the ether. It's just a concept technically that it's almost as if in the event you had this, here's what we're giving you. I don't know if that's probably a bit too loose as far as a legal interpretation goes, but I'll definitely give you an answer on that in an email because that's a good question. Yeah, aside from that, it looks like we're at the end of our show. Apologies for running a little bit late, but I think we answered a lot of good questions here. In the event any of you have any other questions, feel free to email me at kyle@joneskertz.com. We like to be pretty responsive, and we love to talk to the people that attend this webinar. We also love feedback, so let us know if we got anything right, or if we missed something that you wanted us to talk about, so we can talk about it next time. Anyways, we will see you in February if you'd like to attend again. I will. I'll let you guys go for the remainder of your morning. Anyways, thank you for attending, guys. Take care. Bye-bye.